You're listening to Lone Star Community Radio on 104.5 KCCW LP Conroe and 106.1 KZCC LP Conroe and worldwide at irlonestar.com.
Good afternoon and welcome to the Legal Connection with Tony and Cheryl. Tony Lynn Collins and Cheryl Ellsworth Jahani. We are two Texas licensed attorneys, and we are here on 104.5 and 106.1 every Tuesday from 12 to 1 p.m. And you can also watch us live on Facebook if you want to. And you can download the podcast tomorrow on iTunes and Google Play. Today, we're going to finish up our conversation about expert witnesses. Last week, we were talking about expert witnesses, and I think it was a pretty good discussion. And then we're going to get into inverse condemnation.
Yes.
And so, Tony, last week we talked a lot at the beginning of the show about inverse condemnation, so we're going to put that off until we actually get into it, and we're going to finish up our expert witnesses.
Yes. Uh-huh.
Okay, so where did we leave off last time?
Well, I don't remember exactly where we left off, so I'm going to recap a little bit because, I've been dealing with some expert witness issues in some cases I'm working with right now, mainly because a lot of our cases require an expert witness,
right?
For various reasons, which I'm going to kind of recap right now. Now, I guess just in a nutshell, an expert witness is a neutral party that's going to persuade the judge or the jury with your certain set of facts on things that your facts don't present. In other words, something that is, and I'm paraphrasing here, but the expert witness is going to be the person that says, like the announcer, this is,
Troy Aikman. For the football announcer.
Whoever, they're trying to tell you something that's a fact, like from a manual, something that you wouldn't have, and the jury would know unless
they know
were
because
told.
They're an expert.
And without that expert, this law or this fact or this thing that everyone in the universe knows but you, because it may be esoteric to that area, they're going to tell them. And so the person that presents a witness, if it's in opposition or adverse to your side or the other side, depending on which side the expert's on, then you have to have an expert witness that counters them, or else the only thing the jury gets to hear is this one-sided, lopsided point of view that doesn't help your case. And so, and we're going to give a few examples in a minute. But
if there is one expert witness and it's not countered by another, the jury doesn't have to rely on that only expert witness's testimony.
But they usually do. That's the problem. They don't have to rely. But you have somebody that's the authority on, let's say, global warming, and they come in there, and the only expert they have that says, okay, we're all going to die in 2 weeks because there's because of global warming, and that's a fact because I'm a PhD or whatever. Then that's all they've got to work with. And the way the jury charge reads and the way the law works is the only facts that you have are you're only going to take in the facts that are provided you today. No other outside source. So you can't rely upon your own. Reasonableness is important,
sure.
But if you have an expert saying this is the fact, you have to rely upon this to make your decision, then that's all you have. And so you'd want somebody to come in, your expert, that says that's baloney. The world is not going to end in 2 weeks because, and then they give the, like for DNA or whatever the facts are, they give the scientific reason why it won't end in 2 weeks. And then, so you have to have an expert to kind of offset that. But of course, that's not what your case is going to be on. It's always going to be something different. But, and I should have had more of a ballpark on why experts are so important to me whenever they're in our last show. But
yeah.
I will say this is important. The credibility of an expert witness often relies on the belief that experts are, in a sense, neutral, okay? Even when they testify on behalf of one side or the other, because experts are both evaluated on their approach to the facts and asked to testify about it. The perception of both the judge and the jury is that the expert is ultimately on the side of the facts, reason, and careful analysis. And that's why you want to object to an expert that is totally lopsided or not reliable, and you need to do that before trial. And there's a legal procedure for it, but it's not very difficult. And even if you're in trial, if you wait that long to object because you realize this person's a quack, they don't know what they're doing, then you say, objection, Your Honor, before this this expert, let's say they show up and they're wearing something that's completely crazy. You saw them talking in the hall or whatever the case may be. I usually will take them on. You ask the judge to take them on voir dire, and that means if there's a jury that you're asking them questions about their credibility and whether or not you can object to them even presenting their neutral facts to the jury or not.
And do you do the voir dire in front of the jury?
No, never. The problem
so
is
the jury leaves, and
yes.
then you begin to basically examine, interrogate
yes.
the expert.
And the way that works, well, if you have a bench trial, then you're asking the judge to look at it. And the judges have got, if they're a new judge, maybe not, but usually if they're elected judge, they've been in trials before, but that's not a given either. If they're just, politicians, they get in there and they win their election, and now they're on the bench. But if it's a jury trial, they always, the judge will always take them outside the voir dire, outside the questioning of whether they're you have an objection to them being an expert or not. It's always done outside the jury. And I had one where I think we talked about this in the last show, where I had an expert that had done easily $15,000 worth of work. We had an expert report. This was our case winner on a super aggravated sexual assault case. He was going in and he was going to show where the hearsay discussion or the hearsay statements made by the grandmother who simply wanted to have custody of her grandbaby that was all it was. There was no other evidence to support that this sexual assault took place because she made it up. And the little girl, the 4-year-old, was not reliable. She was only 4. Yeah. So my expert witness showed with all of the CPS record, with all of because when you have a super aggravated sexual assault with a child, you don't get to interview the child. Your expert doesn't get to interview the child. The only thing you have to work with is the CPS videos.
CPS videos?
Yeah, the CPS videos, if they have that.
And those are videos of interviews with the child.
Right, and I never got to speak with this child. You don't get to speak with anybody, and you can't get to talk to the grandmother unless she agrees to it in a criminal case. So, or grandmother, whoever the party that's making the accusations. But so all I had was my expert to go off all the information that was provided to me, and it was overwhelming how he was able to prove with his reports that this could not be. There was no sexual assault. There was no physical evidence. There was no witnesses. There was no. She was happy every time the CPS. There's nothing. The judge would not let the state in Harris County took my expert witness on voir dire months after I'd had all my reports filed, and the judge denied my expert because he said that he had not, in one of the many areas where he was licensed and had updated his license, and there was like 10 of them, in one of them, and it was one that wasn't even relevant, he said that he had not renewed his license for that year, so he was not going to let him testify.
Well, but Tony, isn't the rule that they can have not practiced actually for 3 years and they're still considered an expert?
It was wrong.
That was terrible.
Completely erroneous in every way. So what I did was I made an offer of proof outside the jury, and it was another.
And our listeners know what that is. You read what would have been said by the expert into the record.
He testifies as though the jury's in front of him right now, and you ask him all the questions that you would have asked him so that the appellate court can see what he had to offer, and it would be harmful error. If you don't do that, then you don't have reversible error. So there's a lot of steps you have to take, but experts are important for that reason. My expert was going to prove, because I didn't have a witness. My witness said it didn't happen. So it was he said, she said. So your experts are the neutral party that sort of pushes you through that, get you through it, if you can get them on. So there's a lot of this. I couldn't believe that they did that, but it was a learning experience that I guess you have to. The judge just didn't want him to come on there. It was a case where it was a year where it was just before an election, and he wanted to show he was hard on people charged with this, and it wasn't fair because he didn't do it. But anyway, that was an improper ruling, and yes, what you have to do to keep that, to make sure that you've got that, which we talked about in another one of our shows, keep that error preserved.
Preservation of error.
So anyway, most experts believe this to be their role as a neutral party that only goes toward the facts. And they do their work accordingly. Sometimes this means that an expert will discover that their initial opinion was wrong if the facts, reasoning, or analysis support the opposite side. Because maybe when you hired your expert, you didn't tell them everything. Or maybe as the case progresses, your expert finds out that you don't have a winning case because something changed in the facts. The DNA science has changed, or you didn't add something about that plat that they didn't know, that, the reason it was changed was political, or whatever the case may be. Something may have changed. And your expert that you hired, that you vetted, is no longer on your side. And as we discussed last week, as long as an opinion has not been filed with the court, you can withdraw that. And as long as you move in your in limine motion that it not be disclosed that it was your expert, you may be okay. It may not help you on the appellate side if they find out that that was your expert and you switch sides, but it may. So, that may not have been the only reason that you may have lost your case. But no explicit rules prohibit an expert from switching sides or mandate that an expert do so. So you better make sure before you put your expert on that they're still aligned with you. Or worse, what if they were, and this happens too, what if they were paid off by the other side? A lot of times the other side has a lot of money and they get a hold of your expert, and it's not fair, but if you cannot prove it, you may have an expert who may testify against you and you don't even know it. So you have to be real careful about there's a lot of trust involved, a lot of prayer, and I haven't seen that happen but once, but and even then I kind of question whether it was a payoff, but it kind of looked that way. Anyway, questions that arise from the process are often dealt with in the moment, including the ultimate question, whether the expert should be disqualified altogether. So you may not even know that there should be a disqualification until they say something on the stand. And depending on which side you're on, you may be celebrating or, wanting to hang yourself. So that's when you need to, if it's you that's being damaged, you want to ask to approach, and for a few minutes. You want to stop the damage and find out what's going on because, and the judge will usually do that. But then the other side is jumping for joy because the jury has now heard something that may be damaging, but it may not be. It may be something you can mitigate. So
what does something like that look like?
When the expert says they come out, they ask them a question that may be in one of their manuals, like the Texas Society of Physicians or surveyors or whatever. Something's in a manual that you didn't expect or you didn't see, or your expert you didn't cover, and they're asking them something that's in such a way that it's tainting the way the jury is perceiving what's being said, and or maybe that they are lying, that the other side is saying, isn't it true this, and there's no manual, and you may not know it, or maybe they were quoting the manual doesn't say that, or maybe they've got an updated one. Something may occur that throws you off and it wasn't expected. That's when you can say, objection, Your Honor, may we approach? And you stand up immediately and do that because something is not on the path as you see it. And so you're working close with your expert as you go forward because they're the one that's really going to help you.
Right.
Or you hope they'll help you. Now, here we look at some of the biggest questions raised by side switching, which is what that's called when you find out that maybe your expert has switched sides or they're saying something that they're not necessarily switching side, but it's not in your favor. So anyway, some of the biggest questions raised by side switching to provide guidelines for determining when to call for a disqualification if it's the other side. And you can see that they're not qualified. And I have a situation right now where we're having an expert war because the one side has gotten like the top person of all the state. Everybody knows this person.
Right.
The other side got a really well-qualified expert. But on the other hand, I know that what they're saying this expert's going to say is flat out wrong. It's just wrong. I think they're tooling me around right now. They're puffing, so to speak, because there's nothing in any of the manuals that's going to support what they're saying what this expert's going to say. So I need to either depose him, which I don't want to do because it's so expensive,
right,
or I need to because the trial's coming up in about 4 months, so you've got to be working on it like right away.
Oh, I know.
I need to be able to make sure I've got an expert that can show that what they're saying he's going to say is not the case, which is difficult because they've got like the top guy. So now they've got a bigger gun, but he's not going to be saying anything that's he's not going to be neutral, or if he is neutral, I need to be able to use their expert on my behalf by getting a consulting expert or my own if I want to spend the money on it to show that what he's saying is not true and will help me. because I know that what he's saying is not true with the case law. What
So
they're-
you want to impeach him? Is that what you're saying?
I'm going to impeach him. Yes, I'm going to show that if he does come out and say what this other side is saying, the disclosures that he's going to say, that I'll be able to show that I'll be able to use what he's saying to my advantage and flip it so that he'll be my expert. Because what they're saying he's going to say is it's not the law and it's not the facts and it's not reasonable. So anyway, okay, so even though experts are thought to be on the side of the truth, expert switching sides in a case can have onerous consequences, as we were discussing. Some cases involve a switched expert result in the expert deemed disqualified. The attorney being sanctioned if they use evidence, they're trying to quote things that don't exist or it's not current law, or they haven't told you about it, or both. Others, however, continue without a hitch and with the expert now testifying on the opposite side. So the attorney would be saying, I'm trying to think of how an attorney would be sanctioned. If the attorney knew that the expert said something that they were using, if the attorney had knowledge that the expert was saying something that wasn't the law.
So he's my expert, and I knew he was saying something that wasn't true.
Right. And so that would be sanctionable if everybody was aligned and everything was improper. And I'm just trying to think of any recent cases I've had, because it always comes up with you're stunned that the other side says something that simply can't be true. I want to think of the Trump impeachment. I don't know if we haven't had a trial on that yet, but
Right.
if the Democrats came up with an expert that said something that was clearly not true about it, and I can't think of a fact that would be something at the trial yet, so I'll just kind of throw that out. Okay, so for courts addressing the question of side switching, major questions typically include confidentiality. What does the expert know, and what can the expert share with the opposing side? The rule of civil procedure 26 governs discovery may be called into question, or the state court or the state equivalents of the federal rule. So if they haven't disclosed something to you and you find out about it, like maybe this expert had found out new law and they didn't disclose it to you until the trial, that would be sanctionable because they're supposed to disclose that. So they're holding out in knowing that they've got like this bomb. They have to disclose. The expert has to tell you on the other side before that happens.
Okay.
But you have to ask for it too. They just don't give it to you. You have to ask for it. If you ask for it and they don't give it to you, then that's sanctionable.
Right.
Credibility. Is the expert switching sides because he or she genuinely believes the other side is where the evidence leads, or because the other side just became the highest bidder, just like we were discussing? Since the power of an expert relies heavily on credibility, so do determinations of the proper response to a declared switch. Outside influence. In some cases, courts have dealt with the question of expert switching side and the other side hiring them away. They get to your expert, in other words, so that's really pretty bad too. Disqualification, when the correct side is no side. Courts have typically applied one of three standards to determine when the opposing party should have access to a switched expert. In other words, allowing them to switch sides. Exceptional circumstances. The exceptional circumstances standard is based on Federal Rule of Procedure 26 B4B, if you want to go into reading that. But that protects certain disclosures, including expert reports during discovery, unless there's exceptional circumstance. So they have to disclose everything unless there's some exceptional circumstance.
What could be exceptional to keep them from disclosing
Something may have occurred, like within a week or two, or that day at trial, or
they just learned.
Some evidence came out in a fact pattern because of a witness on the stand, and the expert gets to sit in trial with you.
Right.
Rarely does your expert, are they excluded, unless they're also a fact witness, and then it's iffy. Because if you're a fact witness and your expert, there's nothing disqualifying the fact witness from also being your expert. A lot of people do it. In fact, I was declared an expert in a trial where I was actually the party and a witness, and the judge let me be an expert because I was an expert in that field. So it was kind of crazy, but that's something you have to look at. And you always want to make sure your expert's in the court if possible. That should not be something unless, I don't even know why. I guess it would be the judge's call. Okay. Balancing. The standard weighs the interest of the opposing party against potential prejudice to the initial party who hired the expert. So the judge, it could be that you always get to object to whether something's prejudicial. If it's too prejudicial for them to switch sides, the judge may not allow it, but the damage may already be done. But if it's before the court, then you may be able to get them disqualified or not let them be the expert because of the prejudicial influence that it would have if they had been your expert all along. And the judge may allow you another expert if something comes up at the last minute or within a few weeks of the trial. Now, entitlement. A few cases have held that a party is entitled to call any expert that meets the standard for expert witness testimony, whether or not the other party opposes the decision. So, I guess the way to look at that is if you get your expert, if your expert qualifies, you don't, just because their decision may not, the opposing side is now saying you didn't tell me soon enough, that one may not be a reason for them to be disqualified. And I've never seen that happen either. But we're going to go over a case today where the expert was disqualified, and it didn't matter to the appellate court, which I thought was crazy, but we're going to talk about that briefly.
Okay.
The fact that you initially called the expert does not automatically entitle the opposing party to recruit your expert, even if the expert's opinion has switched. So the judge may not allow it. For instance, imagine a situation with the expert's opinion switched from your client is definitely correct to it's impossible to tell which position is correct. So they're neutral. Here, the opposing party will need to demonstrate that the theory is directly relevant to their side of the case, which can be difficult if their stance to date has been our particular interpretation is correct. So if he became neutral, and now if you're saying my side's correct, but now he's neutral, it's going to be hard to say now he's on my side.
Right.
And you definitely not want that to happen if it's like there's money changing hands.
Right.
Really hard to prove unless you subpoena bank accounts. Likewise, an expert witness cannot be picked up by an opposing party in lieu of the opposing party securing its own expert witness, which is what I like to do because it saves you money. If you find out their expert's really on your side, you don't automatically get to do that.
Okay.
Both sides are expected to do their own work in consulting experts, not to sit around waiting for the other side's expert to become available or actively luring the expert away, which is more likely the case. Therefore, it is likely that a switched expert will simply be asked to step out of the case if no exceptional circumstances apply. The prejudice to your case outweighs the benefit to the opposing party's case. The court doesn't recognize entitlement. The expert's new opinion is not directly relevant to the opposing party's case.
Okay.
It's not. They're not just neutral anymore. The opposing party has not acquired its own expert as in attempting to remedy that problem by using yours. Since different jurisdictions use different versions of these rules, it's important to ensure you know which apply to your situation. I will say that my experience is that the court will actually allow you to use, if they're on the stand, they'll allow you to use it, particularly if they're on the stand doing it, that you can actually flip it. It happens in criminal trials all the time. And the other case, and then I'm going to ask Station Manager Dick to kind of give us some of his questions that he had last week. They were so good, but I can't remember what they were. This is a case where the expert witness was, it was a case where it was a land case, and there was a hotel that was in place that didn't want another hotel to use their shared right-of-way, and because that would have quashed their ability to build a hotel. It was in Braunfels, and there's a ton of hotels along I-35. And in this case, it was the frontage land was available to a new hotel. And you know how they do that? They have all the different hotels all globbed together. Well, the existing one said, "Oh no, you can't." Because of the way the plat is set out in the subdivision plat, and what it's where it says there's shared access and not. That the way it's interpreted, you can't use. There was no other access from I-35 but this one road, and they were saying that shared access, we own it. You don't have an easement, and so you can't build your hotel. Well, the city planning commission or the zoning, the city of New Braunfels, or it was the zoning board, or I think it was the zoning board, said we don't agree. We think that they can put their hotel there. We do believe that it's a shared access, so they can put they needed to put parking along the side of the road is what it was. And then so they sued this the hotel that existed sued the zoning board, and they also sued to have a jury decide whether or not that particular plat said what it said.
Wow.
And so they got an expert that said this shared access means that they can't use it. And this is what they lost, and this is why. It says, since it's a public record, I can read about it. It's Infinity versus, let me see. The case is the Infinity Group versus Patel. Infinity contends that the trial court erred in finding its expert witness affidavit was inadmissible as summary judgment evidence. And let me give you a little bit more background on that. The court actually said that they would not let their expert witness they lost on a summary judgment initially for these reasons.
Who lost? Infinity lost? Or Patel?
And they're both hotels, so that makes it kind of crazy. I'll just say the party that is Infinity. The party that had the existing hotel was Infinity.
They didn't want him to
and
do
they
it.
lost.
And Patel wanted to build the
Patel won to
structure.
build it, and it ended up being a Comfort Suites hotel. They filed a motion for summary judgment asserting that let me see, I don't want to get too much on here. I'm just going to go straight back to it. Basically, they said that Miller was not qualified to render an expert. Miller was their expert.
Infinity's expert?
Yeah. He was not qualified to render expert testimony in the case. His underlying methodology was unreliable, and his affidavit contained legal conclusions. Those were their three arguments on why their expert, the affidavit, this was the other side, the Comfort Suites people, they said that they couldn't bring their expert in. And the judge agreed with that,
Really?
which I thought was really lame. I thought, why can't they have their expert? I mean, until the judge hears it, what would they be able to, what was the argument? The argument was ultimately that, I'll read it. They say it much better. The admission and exclusion of expert testimony are matters within the trial court's discretion.
Right.
And that's a Supreme Court, 1995 Supreme Court case in Texas. And it says, discusses admission and exclusion of evidence in general. To successfully challenge an evidentiary ruling, the complaining party must show, so they had a challenge. So this means that the original hotel that didn't want them there, now the ball was in their court. They had to show that the judgment turned on the particular evidence being challenged, and that the error in admitting or excluding the evidence probably resulted in the rendition of an improper judgment. So the burden was on once they lost the case, the burden was on their side in the appellate court to show why there was error. The evidence at issue consisted of the expert's affidavit regarding the proper construction and effect of the relevant plat records. The dispositive issue in this case is whether the plat record created an express easement for shared access to Infinity's private road. That's all it was. You're looking at the plat. Was there enough there on that plat to show there was a shared easement and giving them access, even though they owned the property, the people in the back? For reasons discussed in greater detail below, which we will not discuss for time reasons, we hold that the plat records are susceptible to only one reasonable, definite interpretation after applying the rules of contract construction, and thus present purely legal questions. As such, the issue in this case is not a matter for which expert opinion will assist the trier of fact. And remember, the trier of fact is the judge here, not the jury.
Right.
So the judge can, I get crazy over summary judgments,
Yeah.
they're not constitutional, but the judge said, I don't agree that you even need an expert because in my opinion, this is basically what the judge is saying, in my opinion, I think it's reasonable and I don't need your expert. And so she said, your expert goes. And fortunately, it was summary judgment that all goes to the appellate court. But the appellate court agreed too. The appellate court said, let's see, the case that they referred to said, expert witness must not testify regarding an opinion on a pure legal question, a pure question of law. Let me see. Infinity makes no showing of how which was the hotel in the back, of how the exclusion of their expert's affidavit probably caused the rendition of an improper judgment. And after reviewing the summary judgment record, we conclude an error in excluding the affidavit testimony was harmless. And so when you have a summary judgment level expert, you really are just talking to the judge. And so now you go right back into how close is the other attorney to the judge? How is your case going? Does your attorney get along with the judge? Now you've got this whole sort of symbiotic, family thing going on, and you're now looking at the politics of the court too. But in this case, when they got it out of the politics of the court, the appellate court agreed. They said, we believed, and it all boiled down to the actual plat said shared access. They had shared access.
Right.
And the only thing they wanted to do was put some parking spaces on part of it. They weren't taking the access away. And that's why they won. And so with that example, the expert
Comfort in one.
Comfort Inn
Patel.
one, and they built it. And if you go down there today, you'll see a beautiful Comfort Inn with shared access. And the other people didn't go out of business; they were just being mean.
Yeah.
And I think it had a lot to do with that too. There was no reason why these people couldn't build a hotel on
They
their
didn't want the
their lot.
competition.
They didn't want the competition.
Yeah.
That was what really was.
Right.
A lot of times in these cases, you have to look at the underlying argument. What's really going on here? Because that's what the judge is going to be looking at
Sure.
more than likely. Okay, so that being said.
Okay, are we going to ask questions?
Yes.
Okay, I want to ask you a question first. Okay, what happens? I mean, you talked about paying your expert and how they switch sides and stuff like that. But I think our listeners think, and we talk about this quite a bit, can someone really be an impartial expert if they've been paid by one side to do an examination and testify?
That is when the opposing side takes them on voir dire or objects in writing after they designate them. And you look at what their basis is. And so what an expert does is through their knowledge, experience, qualifications, all those things that show I'm a neutral expert. If you're expert, and that's a lot of times you have to, just like we were discussing in our last show, a lot of times you really need an expert.
Right.
Because what you think may be reasonable as an attorney or your person has told you, and it just seems reasonable, it may not. You may need an expert to tell you, like in this example, we have a manual that says, here's how a plat's interpreted. Our society of surveyors or landmen or whatever says that this is how this is always interpreted. And if you combine that with case law that says, and we have a case that says the exact same thing in the United States Supreme Court, then that's when you want to negotiate or look at a different angle because the expert has been neutral. So, but if they're paying the other side, you're exactly right.
Right.
They're going to be aligned with the person. Follow the money. Who's paying you to say this? And then really follow the money. If you get an adverse ruling on something that's clearly in error, then you do like in the Trump thing. You follow the money and you say, why are we arguing about the Trump impeachment if the core issue here is whether he was investigating a something that looked like there may be corruption.
Right. So
and
valid.
The underlying corruption was Biden's son receiving millions of dollars and not being qualified to be in that position.
Anyone. Right.
So why aren't we investigating that first? I mean, that was
Right.
all he was asking for. And so if you don't really, in that case, do you need an expert? You really do need an expert to some extent and do some investigation to follow the money. Because usually, and I say this all the time, in the world when you've got issues, if you follow the money, you're going to find out where the core problem is because the love of money is the root of all evil.
Okay, well, talking about following the money, this is another problem with experts. And I'm thinking about our listeners that are just kind of regular people, not completely loaded and all rich and all that. Experts are expensive.
They're very expensive.
And
We
then
talked about it in
how
the last
does
show.
that impact justice? I mean, if
If you can't afford your own expert, well,
Yeah.
that's when you get with your client and you say, just because someone's married to you or just because it's a cousin does not disqualify them from being an expert. So you need to find somebody that will do it for you, at a cut rate. And hopefully if you win, they'll get paid. But that's few and far between.
It really is.
Really. But I always, as an attorney, I explain to my clients, I can't cover you for this. And in my case, that I was talking about my super aggravated sexual assault case, my guy was in jail. What was he going to do?
Yeah.
So first I asked the judge to fund part of it, which he did. The court funded part of my expert, but not nearly enough. It was just a pittance,
Right.
And then my expert saw how bad it was, and he volunteered to do the rest. And if I got some money from the court from it through a victims assistance program, then he could get paid. But you just have to be really creative about funding and if you have a case that you're even kind of iffy about, and you've got to get a consulting expert, and there isn't somebody, you just got to let your client know they're expensive. And let's just say that none of that works out.
Right.
It is lopsided that the other side has an expert, and it's unfair. In a civil case, you can't get the other side to pay for it.
No.
So you've got to be really creative, and so that's when you do your homework. You use their expert's opinion. You ask questions. As an attorney, you do research. You ask your clients to do research. You go to a college. You go to a professor. You go to a public resource that may do that wants to do maybe a research study on something. I'm just kind of throwing it out there. But if you really need an expert and you pray really hard about it, you will get an expert because just like I heard a quote from the Kobe Bryant, that's so
Yes,
tragic. I
wasn't
mean,
that
I was in
terrible?
tears. I mean, I don't know even why I didn't know this guy, but I was in tears about it. And then I found out that he had gone to mass at 7 a.m. The morning, 2 hours before. He went to the 7 a.m. mass, and he was, the helicopter crash. And there was an article.
Thank God he did.
Well, there was
that he had faith and.
Yes. Oh, I was so
Yeah.
excited about that. But I'm relieved. But it said that he had made a quote, and the priest said that God will not give you anything that's too much for you to handle. And he said
That's a
that
Bible
changed his
verse.
life. So
Kobe Bryant said that?
yeah, he said that the priest told him that, and that one quote that he said that's what the priest told him that turned his life around. From 2003 forward, that God will never give you too much to handle, and that I will live by that. I say just never give up. So if you need an expert, or you think, you always ask in the hierarchy of things, low, and be humble and do the best you can, because you don't know why things are happening, but you got to keep fighting. And a lot of times you will find experts that way. So
Okay.
now, do you remember what your questions were last week? Station manager Dick. I can't remember at all what they were, but they were really good questions.
He was asking us about expert witnesses and how much they get paid, and that it's a very lucrative field.
And I was talking about that and asking, how does a court recognize a qualified?
That's right. And
Expert.
that's the whole. They go through, and I could go through
It's
all
their
my notes
CV
here,
and
but,
all the stuff
But
they've
basically,
done.
they have to have the background knowledge.
But who approves it? The judge?
Well, the judge doesn't have to approve. Well, sort of. You get your own expert, and then you provide in your disclosure, it's required, their resume, and then you put in the actual narrative of the disclosure, which is just a legal discovery process. You say what their proposed opinion is going to be, and then a lot of times the actual law requires that the expert submit an opinion by a date certain, and they support it with their qualifications. And then if all of that, the other side has got to object. The other side says,
in if they don't object.
Right,
the other
right.
side.
So you've got to do it timely unless something comes up. But like I said, my expert there was an objection made at trial, and so that wasn't timely at all. It just depends on which court you're in.
But then he still got disqualified, right?
Yeah, mine got disqualified. Yeah, which was
Even though it wasn't timely.
So, but there's there's a rule in the Texas Rules of Evidence, so it's not federal, and it's civil. It's Texas, but the Texas Rules of Evidence goes civil and criminal. That says you have to designate your expert within a time certain, or you don't get to use them, and you have a certain period to object. And if you don't object within that time, then the other side, then they come in. So there's some legal wheels that turn in that, but ultimately, if you've done your due diligence and you've submitted an expert timely, it's really going to be completely up to the judge, because I had one judge recently disqualify a very qualified and needed expert, which we believe was harmful error. And then I had this other trial, maybe about 10 years ago, where I did everything that I was supposed to do, and the court even paid for it, out of the public funds, because this guy couldn't afford it so he'd be exonerated, and then the judge wouldn't let him in. So that made no sense to me either.
So would you say in certain fields, if you work, it'd be a smart thing to research to become an expert witness?
Oh, yes.
Oh my gosh, that is so lucrative. My husband's an anesthesiologist. He wants to be an expert witness. People advertise to be an expert witness.
Yeah,
the problem
they
is,
sure do.
a lot of times when you've got like professional expert witnesses, they're good, but I'm always a little bit leery, because that's all they're doing. Oh, if you're an expert witness, let's say like Dr. Ben Carson, he's a politician, and I guess he's the head of Department of Health and something. He's, whatever he's head of some department. He's still, I don't know if he's still a practicing doctor, but he's still keeping up with all of the current research, and he's doing I guess with legal at CLEs. So I want somebody that I've looked at, and I'm weary of professional ones. So sometimes it's all you can get is the professional experts.
Well, I mean, because I feel like, because I know my wife, she's a nurse, and she mentioned, because I was just curious about the different fields nurses can be in, especially with education and then qualifications. She said probably the highest paid nursing position is an expert witness.
Yes.
But you have to do a certain type of program through the nursing I guess, the nursing department or field or the Texas State Board or the...
Well, sort of. I just recently, I was having just one heck of a time finding a SANE nurse, which is a sexual assault nurse examiner. And there is a qualification for being you have to go through, you have to be, I guess, there's a test for it or something to get that designation. And so I couldn't find any SANE nurses that could represent my client because it was a criminal case, and all of the really good SANE nurses had already been vetted out by Harris County, and so nobody could work for me. Harris County had them all disqualified because they said we can't because of our position in this hospital, that we've worked with them before and we think they'd be a bias, and so I couldn't find anybody. Well, I found one by going to the board of licensing, I guess the Texas Board of Nurse Licensing or Examiners or whatever, and then I just went down a list. I literally just started cold calling about 50 nurses. That's how hard it was. And then I finally found one who was an amazing expert for me. The thing was is that she didn't have to be, there wasn't a legal test that she had to taste to be an expert. But what I learned was the place that she worked for would not allow her to be an expert unless her group of nurses required her to be. They wouldn't allow her to testify as an expert while she worked for that group unless she had passed some of their requirements.
Oh, okay. So that's internal.
Yeah, it was an
policies.
internal policy, right? But I don't know that when I've used a lot of experts, there was no, you don't want to go get an expert. I mean, I could get anybody. I could get you to be one of my land experts, but you would be a terrible expert unless you had some land background. And then, with the case I have going on right now, the other side has got this land examiner who's been basically blessed by the Pope. And how am I going to find somebody that qualifies for that? But what's going to help me is I know that what he'll testify to, he's just going to be shooting. I don't know what all the phrases are, but spitting in the wind.
What would you say for a listener who's interested? What's the top 5 fields that lawyers constantly use? I know that the land one's a big one here in Montgomery
medical
County.
experts are huge.
Medical experts.
Medical
experts.
And then nursing, the medical, but from a nursing standpoint, and the expert medical, they're all very
that's
specific.
medical,
Yeah.
but you got your physicians, you got your nurses. I am working on a case right now where I have a corporate fraud expert. I don't think
there's very few that have the clout and the background to be actuaries and corporate to determine what the value of a business is. It's very, very difficult. And everyone needs them for divorces and for
absolutely. Business
corporate
valuators,
arguments.
Business valuators
They're
are right on up there at the top.
And they make a fortune, business valuators.
Trust me. So what else, Tony? That's 3. What else do you think?
The specific fields in the medical field, but doctors always make a lot of money too, but you may need an expert in a medical malpractice case for your EMS or your emergency room doctor, a separate one for each field because there's that different. So, but nursing's a big one. Medical's a big one. I separate physicians from nursing.
Business valuators are big ones.
But
Corporate.
I think the best place to be an expert would be where there's not many in that field, and that way they have to go to you because it's supply and demand. I have to pay a fortune for ones where I can't find anybody, and they're booked up. And
true.
Yeah. But I think being an expert, Jim had thought about doing it too, and they offer all these courses.
They do, and I think that was
witness.
part of Dick's question. If you want to be an expert, if you're in a field that you'd like to be an expert in, I would go look up expert witnesses and see what all their qualifications are, and I just go after them one by one.
Jim gets brochures in the mail all the time to see if he wants to be an expert witness, and they send you on cruises and to have those seminars to do, and they're kind of expensive, but he hasn't done that yet. Oddly, he is getting not brochures, but he's getting job offers, and he does not want a job, to my knowledge.
Doctors always do.
Yeah, but in Alaska.
Oh,
and so he was laughing. He's like, don't you have your Alaskan bar? We should go to
You
Alaska.
do, that's right,
And I'm like,
Tony,
I'm going to go up
no.
there, and we're going to, and I'm going to run for governor because I don't think there's anybody in that
Like Sarah
state.
Palin?
And so I'll be like, I can see Russia from... No, we're not going to Alaska. I just, we went up there, and I thought it would be a fun place to have... if I ever wanted to do a case, to do a case in Alaska. I don't know
Well,
why.
Rick Friedman, he's up there in Alaska practicing, and he's the guy that's writing all the books and stuff. One of the best trial lawyers ever,
Okay.
and he practices in Alaska.
I just was of the mind with all the immigration that Alaska would be a very good place for immigrants to go because there's so much land and they want people up there. And so for some reason in my head, I was like, well, I need to go get my Alaska bar license.
So you did. Okay.
So there you go.
Okay. Well, so
Any other questions, Dick? Because I like your questions.
I mean, I think it's something that you can answer the ones I always thought because it didn't really make a lot of sense about the approval and how
Right.
influential they can be in.
Right. So
case.
you can put it about pretty much you can ask anybody to be your expert, but the other side
May
and I would
object.
say that if you ask somebody to be an expert that's completely disqualified, I mean, there's just no way. The judge might sua sponte, which means just on her own say no. But
Well, why wouldn't the opposing counsel always object?
well, they may not because they know your expert's so bad. They may want your bad expert
Okay.
up there because it's going to
or
completely.
they may object
you'll
to just
get no
object
disrespect
and
from
be
the
a
judge.
jerk. I was watching a hearing the other day where one side had an expert child, whatever psychologist, and the other side had one, and one counsel was just objecting, and the judge was saying, "Why are you objecting?" And she was saying, "Well, because we just don't know what we don't know, and we need to know, but
Well,
we
I mean,
don't know."
You also,
it was a joke.
That's pretty bad too.
That was
but,
bad.
But they're experts, actually. I mean, it's like everything else. Everything is about the facts. And I just there was a quote by like the Archbishop from I guess there's an author, a very famous one named Chesterton, that said he was quoting this because he said an egg is an egg. What is.
Did you say an egg is
An
an
egg
egg?
is an egg. If
Or
it is,
did you mean an egg
an
is
egg.
an
Yeah,
egg?
an egg. You don't say egg.
No.
Where are you from? I thought you're from Dallas.
I am. We say
Okay.
egg up there.
Okay, I was gonna say there's something wrong with you. I don't know what egg is. What is that? Excelsius or something?
So an egg is an egg.
Sometimes
Okay.
your expert is going to try to show that there's some fact that's really important or give it a different weight than it should have, and that's when you just attack them with all of your objections, or maybe the jury's going to see through it. But a lot of times, if you're experts, if you just don't have a case, then you've hired somebody and they're doing the best they can. That's why you get an expert out there. They may not want to object and that's why I like to use the other side's expert a lot of times because if they're an expert, they should be neutral.
But you were saying you get an expert out there and they may not want to object because you mean the other side may not want to object.
Well,
Why?
the other side may not want to object because it's helping your case because they're saying things that are just ludicrous.
Oh.
But on the other side, if the expert that they use is using facts that aren't even facts and evidence, they're just trying to use hypotheticals that don't even apply, but they've kind of weaseled the way in, and I've seen that happen before too. Well, that's not right. If we're talking about like a corporate expert and they're going to use an example that is something that's not even on point, then and that's kind of what I have in this case I'm working right now. It's the other attorney is Harvard educated and went to he's like the top of the world attorney. They have top of the world expert, and he's pointing me to all of these cases that showing that I can't win, trying to like argue with me. Why would you want to argue with me? Of course, we're adverse to each other, and we're gonna have to agree to disagree. But fortunately, he's showing me cases that are not on point. It's
Good.
like I'm just gonna shut my mouth and go forward.
Well, and that's one more question I want to ask, or I want our listeners, because I know they're thinking about this. So you keep talking about this expert, this greatest expert of all time. I mean, I just did a divorce where I was up against the greatest divorce attorney of all time. In the state of Texas. But don't you think it really comes down to believability? So you have the best expert of all time,
Oh, yes.
and my expert's just qualified, And the truth is, I mean, what do you think about the jury actually? Do you think they're really going to be swayed by the best expert of all time?
Well, I no, because I have to go back way before the time of probably station manager Dick, but the OJ trial, and you've got all
Right.
these experts, and what they went on was if the glove don't fit, you must acquit. I mean, basically, a number of other things probably kicked in, but that's the phrase you hear because he put a glove on that. That obviously had weathered and was tight, and he may have gained weight, and it was ridiculous. But of course, that jury decided that was it. But all the experts in the world did make a difference in that
Right,
case. It was
right.
just what the jury
I
saw.
know in the TV show Boston Legal, the running joke of the expert witness was Al Sharpton.
Oh, and
really?
why? I don't.
Really?
Well, like whenever they get stuck, they're like, "Oh, we'll call favor to Al." an owl come to be an
Yes,
expert
yes.
witness.
Expert.
Yes.
And
So
that was
true.
kind of the running joke, is he could convince the jury of whatever.
Yeah, right. The expert, right. That's what I'm saying, that if your expert can get up there, and that's when you have to know your case. You can't, if you do have somebody that's very persuasive and they're not using facts, because an egg is an egg, then, and your jury doesn't see that, then you've got to have the wherewithal to show where that's wrong. But you run that problem too with somebody that the jury may like. Because they're going to vote. It's a popularity contest to that extent too.
I know.
Juries, you go talk to them sometimes, and
Unfortunately.
you're like, "Why did you rule this way, or why did you rule that way?" And you're stunned because the things that that one DWI case, and they're like, "Well, we heard a second officer in the background
very back,
whispering that he saw that the
six things were there,
The stegmus was that he did see it," and I'm like, that wasn't even an officer, and that wasn't what was said.
And that
it was
wasn't
like, that didn't
pointed
that
out.
wasn't even in the nothing about that was right. It was just, but the jury got together back there and decided they heard this ghost back there, and of course it was a bad decision on our part, but the judge got it right, because when we asked for a new trial, because that was
Right,
completely wrong,
right.
the judge overturned it.
Right.
So the jury can get it wrong too, but. So you just don't know, and that's another words of wisdom of people getting a jury. You don't know. Juries are, no matter how great your case is, you don't know what a jury is going to do. You just might get a group of people that somebody decided that they're going to focus on something that was in trial, but they put so much weight on something that was not even. They've all convinced themselves that it was said something that didn't. We were going to win on appeal on that, because if you got the whisper on the transcript, you would see that that's not even what was said, and so that would have been no facts that didn't support the the weight of the
Verdict.
evidence or whatever. So,
Yeah.
okay, so how much more time do we have? 2 minutes.
Yeah, so I guess we're not going to get to inverse
We're not going to get into
condemnation
it, but I want
today.
to cover why it's important, so we can give like a little taste of what's going on with it. Because
And we're
we
gonna do it next
are gonna
week.
do it next time. And I just wanted to say the reason why it has to do with inverse condemnation. It was a ruling that was that came about in the end of December. A federal judge on December 17th ruled the U.S. Army Corps of Engineers was liable for damages caused by its decision to retain floodwaters upstream of the Addax-Barker reservoirs during Hurricane Harvey. That was a huge decision, okay? And the reason it's important to our listeners, because any public utility, whether it's a gas utility, electric, a phone tower, flooding, it's important because you may be injured and you may have a case and you didn't know it. And if your home, and we're going to talk about flooding, because in Montgomery County we're running right now. We could have flooding at any time with all this development going on.
Right.
If your home or business sustained flooding after any release of water by dam, and in this instance they're using the example of the Addax or the Barker Dam releases at 2 a.m. on August 28th, you may be able to have a case of inverse condemnation because your property was taken without you being paid for it, with the
compensation.
taking. And it doesn't even matter if you had flood insurance or not. The government owes you, or the public entity owes you, if they take your property without paying you.
And then we're going to talk about that next week. Thank you for listening. We want to remind you.
To serve God by serving others.
All right. Have a great week, guys.